Good morning. Are you Eric Segrest?
Yes, ma'am.
And this is cause number 25, DCCR 1836. Mr. Segrest is charged with burglary of a habitation. And what is the announcement?
Judge, this was one that we had reset here from a few weeks ago where Mr. Smith was trying to reach out to the complainant in regards to this case, some paperwork that she supposedly had came and filed with the DA's office. To date, my understanding, he has not been able to get with her. I've tried to call her, but hasn't got any answer. I've got a separate number that supposedly is supposed to be good to reach out to her. I've given that to Mr. Smith. And of course, we're asking for a little time to see if we can do that. I've talked to my client. He did want me to ask about possibility of a bond reduction.
Well, let's do this because that would make sense if you can't get in touch with her. I'm going to reset it 1 week. Mr. Smith, see what you can do with that new information, and let's get an announcement next week. If for some reason you can't get in touch with her, but the state's going to proceed with the case, then we'll talk about a bond next week.
I'll file a motion to that.
Perfect. Thank you. All right. We'll see you next week. All right. Will your client waive the formal reading of the motion?
He will, yeah.
I didn't already have that. Sorry. This is cause number 25, DCCR 0895. And Mr. Douglas, I have a motion to revoke your unadjudicated probation. This shows that you were placed on probation November 18th of 2025 for the offense of obstruction or retaliation, a third-degree felony. And that was a 3-year deferred probation. Is that correct? And this motion alleges that you violated your probation in count 1 only by failing to act in a courteous and professional manner, by incurring 3 new incident reports while housed at the Jefferson County Jail, including a physical altercation with another inmate on November 29th, 2025, which was the same date of your last hearing. And so is that true or not true?
True.
Did you enter your plea of true to count 1 freely and voluntarily?
Yes, ma'am.
And because it's actually true?
Yes.
So you never even made it.
I know. That's just.
Yeah.
And I guess once you did that, you decided, screw it, I'm going to do whatever I want because I already know I'm going to get in trouble because you've been acting like an absolute fool in our jail. I'm not sure 4 years is enough. I need to think about this for a minute. I mean, is it really that hard to follow the rules?
No.
You didn't want to get out? You did? You got a problem with showing yourself while masturbating to the female officers out there, don't you? You don't?
Ain't got no problem.
You don't have a problem? You just like to do it and you think that's cool to do that in front of them? Even though you know you're going to get written up and go to prison for that? Was that worth it?
No.
Have a seat in the jury box. I'm not sure that I'm going to accept this agreement. Mr. Wara, in cause number 24, DCCR 2344, the state has elected to proceed on count 1 only. It alleges that you committed the second-degree felony offense of aggravated assault with a deadly weapon from October 19th of 2024. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you actually did what they charged you with? I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Ms. Holmes?
Yes, ma'am.
And do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreement that you've made with the district attorney, that you will be waiving or giving up any right to appeal?
Yes, ma'am.
Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes.
State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Juarez is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily, find that you're mentally competent and understand the nature and the consequences of your plea, find sufficient evidence to find you guilty, and at this time, find you guilty of the second-degree felony offense of aggravated assault with a deadly weapon. Sentence you in accordance with that agreement to a term of 10 years in the Institutional Division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. There will be an affirmative finding of a deadly weapon in this case. I am handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have any questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Ms. Holmes. All right. Good luck to you, sir. You can go back with the bailiff. There you go. Good morning. Are you Jonah Johnson?
Yes, ma'am.
This is 25 DCCR 1775. Mr. Johnson, you're charged with the second-degree felony offense of aggravated assault with a deadly weapon, and that's from August 31st of 2025. And what that means, sir, is if you go to trial and you're found guilty, the range of punishment is between 2 years and up to 20 years in prison. Do you understand?
Yes.
Can you check if there's any of his in that pile? I have here on the tablet a plea bargain rejection that shows that the district attorney's office has made an offer if you wanted to enter a plea of guilty for a 15-year term in prison. You have every right to reject that, have your case set for trial. I just want to make sure you understand what the possible consequences are if you go to trial and what your options are if you wanted to plead guilty. And do you understand all of that?
Yes, ma'am.
And do you want to reject that offer and have your case set for trial?
Yes, ma'am.
All right, we'll get that done. Mr. Johnson, Ms. Holmes has been appointed to represent you, and she's one of the attorneys who handles a lot of cases for me as a court-appointed attorney. With your permission, I can release her and appoint another attorney today who could begin preparation for trial a little quicker. Is that okay with you? All right, so Ms. Holmes, you are released. Mr. Johnson, we will appoint someone today. They should be out to the jail very soon to begin preparation for trial. All right?
Yes, ma'am.
And there's none. And just because I get on to everybody for having incident reports, thank you for not having any incident reports. I mean, right? I feel like I need to. Seriously, though, it can affect your case. It can affect how the DAs look at your case. It can affect how a jury looks at your case. Continue doing what you're doing in jail, following the rules, because that's only going to benefit you, okay?
Yes, ma'am.
All right, you can go back.
This script shows different court hearings with several defendants facing serious criminal charges. First, Eric Seeger is charged with burglary of a home. The lawyers have not been able to contact the victim, so the judge resets the case for 1 week. The defense also asks about reducing his bond, and the judge says they will discuss it next week if needed next. Mr. Douglas is on probation for a felony. He admits that he violated his probation by getting into trouble in jail, including fighting and inappropriate behavior. The judge is very upset and considers sending him to prison because he did not follow the rules. Then, Mr. Ware pleads guilty to aggravated assault with a deadly weapon. The judge makes sure he understands his rights and the consequences. He is sentenced to 10 years in prison and loses his right to appeal and to own a firearm. Another defendant, Jonah Johnson, is also charged with aggravated assault with a deadly weapon. He rejects a 15-year plea deal and chooses to go to trial. The judge appoints a new lawyer for him and advises him to keep following jail rules. Other cases include evading arrest with a vehicle, robbery, and competency evaluations. In some cases, the judge finds the defendants mentally competent to stand trial and resets their cases. To allow lawyers more time to prepare. Overall, the court reviews evidence, checks if defendants understand their rights, decides if they are mentally competent, and sets future court dates or sentences.